let me quickly start because there is a lot to talk about this. So I want to start with, some introduction about what is this European Court of Human Rights and why this judgment is important. So the European Court of Human Rights is one of the regional human rights mechanisms that was created after the Second World War under the auspices of the Council of Europe. And it is actually the enforcing and monitoring mechanism of the European Convention of Human Rights. The court is headquartered in Strasbourg, France, and it has compulsory jurisdiction over all member states of the Council of Europe. So accepting the jurisdiction of the court is compulsory for all member states of the Council of Europe, and that is something that hugely, changes the nature and the characteristic of this court in compared to other, regional or even global human rights mechanisms that we have around the world. The Council of Europe has 46 members. It's a completely different organization than the European Union. The European Union has its own court, which is the Court of Justice of the European Union. But the jurisdiction of the European Court of Human Rights is much more extended, considering that there are 46 states that are members of the Council of Europe. So in that term, it's a very important regional human rights court that is also leading the debates on international and European human rights law with a very impactful jurisprudence and case law that shapes the arguments around human rights around the world. The way that the court works, usually after exhaustion of domestic remedies, so everybody should go first in front of the domestic courts within those countries, and once domestic remedies are exhausted, then they can bring claims in front of the European Court of Human Rights. First, it will be in front of one of the chambers, which they do have 7 judges. And in rare cases, in rare instances, cases may end up in front of the Grand Chamber of the European Court of Human Rights. So once the applicant or the state are not satisfied with the judgment of the chamber, they ask for a referral to the Grand Chamber of the European Court of Human Rights, where they have actually 17 judges that are going to deal with the case. And that's how a case can end up in front of the Grand Chamber of the European Court of Human Rights. So that's how the system works. What makes this court interesting and important is that, first, this is an international court where states can be sued, but individuals can bring claims against the states. So we are not talking about the International Court of Justice where states are bringing claims against states, right? We are talking about the forum that individuals can sue states for violation of the rights under the European Convention of Human Rights. So that's the first thing that makes this court interesting in terms of realization of the rights of individuals where they can sue states for those type of violations. The second thing, and the most important thing about this court, is its enforcement powers. Because of the structure of the Council of Europe and all those connections that that organization makes with this structure, the European Convention of Human Rights and the European Court of Human Rights, the enforcement of the judgments or the jurisdiction of the court are compulsory for those member states. So they are required to comply with a judgment of the European Court of Human Rights when it finds a violation of the applicant's rights and asks the state to provide remedies or, fix domestic procedures or those type of things, right? So we are dealing with such a structure in the case of Caster Semenya. It is a case that started with a dispute over the private regulations of World Athletics, an entity that is based in Monaco. And then it went to the Swiss Federal Supreme Court, the only forum that perhaps had the power to review the CAS awards, the Court of Arbitration for Sport Awards. And then after that, it went in front of the third section or third chamber of the European Court of Human Rights, where it's delivered its judgment in July 2023. And then after that, Switzerland asked for a referral to the Grand Chamber of the European Court of Human Rights, where 17 judges are going to deal with this issue, right? So this trajectory makes this case also interesting and this judgment very important. A dispute about the private regulations of a private sport governing body ended up, at the top of the human rights pyramid in Europe, in front of the Grand Chamber of the European Court of Human Rights. A quick review of the facts in this case. So as many of you already know, Caster Semenya was a South African middle distance runner that was subjected to sex verification, testing rules of the former International Association of Athletic Federation, or IAAF, in 2009. So everything started pretty much from 15 years ago, including subjecting her to physical examination of her genital areas. This process led to the imposition of testosterone-reducing treatment on Caster Semenya. She was taking medications as a condition for competing in the female category. And Caster started complaining about the side effects of those type of treatments many times during that period. Following the suspension of those regulations in 2015, in the Duty Chand case by the Court of Arbitration for Sport, Caster Semenya stopped hormone treatment and continued to compete. However, in 2018, the IAAF introduced new regulations for female athletes with differences in their sexual developments, or DSD regulations. That is something perhaps that you hear a lot during this conversation, requiring female athletes with certain intersex traits, that's what the court also says, and naturally elevated testosterone levels to reduce and maintain those levels below 5 nanomole per liter to compete in these specific events. Caster Semenya challenged those rules, refused to comply with these new set of regulations, and brought a case in front of CAS, which ended up before the Swiss Federal Supreme Court, and then the third chamber of the European Court of Human Rights, and then the Grand Chamber of the European Court of Human Rights. The other interesting aspect of this case is that for the first time, substantive human rights arguments, claims of violations of substantive human rights, the right to privacy, the right to non-discrimination, the right to health, those type of things are being raised in front of the court within the sport context, right? So the previous cases, the Mutu Pakistan case, the Platini case, they were only concerned about procedural rights under Article 6, the right to a fair trial, or those type of things. The Caster Semenya case, raised claims of violations of the right to privacy, non-discrimination, the right to an effective remedy, and those type of things. So this case is, again, a landmark case in terms of dealing with these issues for the first time coming from, the structure of international sports. Another thing that makes this case really important and interesting is, so for me, at least, as a human rights scholar, this was like riding a roller coaster, right? Since, the case arrived at the European Court of Human Rights, it was a first ride on a roller coaster, unexpected turns, up and downs, sharp turns where nobody expected. First of all, the third section of the court had a striking shift of perspective when we compare it with the Court of Arbitration for Sport and the Swiss Federal Tribunal. While those two first forums, CAS and the SFC, Swiss Federal Court, completely focused on issues of fairness of sport competitions, and I want to call the attention of all of the audience here to this specific concept, because this is really important, and I'll get back to it later. While they were only focused on fairness of sport competitions, when things arrived at the European Court of Human Rights, we saw a complete shift of perspective. There is no word about fairness of sport competition in the judgment of the third section of the European Court of Human Rights. The only thing that mattered to him was that this is discrimination based on sex, and this is so intolerable that we cannot find any justification for that. Basically, they are saying, what is fairness of sport competition, right? We have no precedent on that. There's nothing that says whether that can be an exception to the rights that we apply under the European Convention of Human Rights, right? So that's the first interesting, novel issue in this case, which was touched upon by the majority of the third section and also by the dissenting judges in that case. They only focused on sex discrimination in the case. The third section found violations of Article 8, right to privacy, Article 14, right to non-discrimination, and Article 13, right to an effective remedy, and didn't see it necessary to deal with Article 6 questions, fair trial and procedural rights at all. So that was interesting, that why they did not engage in that specific, topic. When the things came in front of the Grand Chamber of the European Court of Human Rights, there was a sudden shift again, right? They denied jurisdiction on Article 8, Article 14, Article 13, and only engaged with Article 6. Right, this is the roller coaster that I'm talking about. So lots of turns and up and downs that nobody expected from that. So this was the trajectory of this case until it reached the Grand Chamber of the Human Rights. The holding of the Grand Chamber, if I want to be very precise on that, first they excluded two issues from the scope of the Grand Chamber judgment: the question of independence and impartiality of CAS. I will get back to this at the end of this conversation. And then discussions under Article 3, degrading and inhuman treatments resulting from the ESLA regulations, because they said the third section already found that claim inadmissible, so we don't have jurisdiction to deal with that article. So we set aside those arguments here. Then they moved to see what are the claims under Article 6.1, 8, 13, and 14. The first question for the court was whether they have jurisdiction to deal with these claims. The court, the Grand Chamber, 17 judges, unanimously found Article 6.1 claims admissible. Those are fair trial procedures, right to a fair trial, public hearing, independent and impartial court, those type of things. They found claims under that article admissible. But they denied jurisdiction under Article 8, right to privacy, 13, effective remedy, and 14, non-discrimination, by a vote of 13-4, saying that Switzerland had no territorial jurisdiction over those type of claims. So they denied those type of claims under the ECHR. Then they moved to the merits of the case under Article 6.1, and with the vote of 15-2, they found a violation of the applicant's rights after highlighting specificities of the CAS compulsory arbitration and deficiencies in CAS analysis, and also the Swiss Federal Court analysis in this case. There are three separate judgments, separate opinions by the judges that are attached to the judgment. The first one is the concurring opinion of Judge Shimachkova, hopefully I pronounced the name correctly, where she discusses that the majority should have first, addressed the question of independence and impartiality of CAS. And that was a part of, this whole analysis, that they should have mentioned whether the Court of Arbitration for Sports is independent and impartial. I get back to that later on. Then she joined another three judges to say that denying jurisdiction was actually not a correct decision in this case. So the court should have found jurisdiction over right to privacy, non-discrimination, and effective remedy as well. And then there are two judges that are dissenting on finding a violation of Article 6.1. saying that the Swiss federal court hasn't done anything wrong. Everything has been fine. So even there has been no violation. I'll get back to that if we had time at the end. So that has been the trajectory, a bit of the facts, a bit of the holdings of different courts in this regard until we got here and we have this judgment. So in this case, this is what makes this case complicated. We have a South African national who has lived in South Africa her whole life and is bringing a claim about regulations that have been adopted in Monaco, but the case is against Switzerland, right? So this is the complications that the sport is creating when it comes to international human rights law. With that compulsory arbitration procedure, everything has been distorted, right? The regulations have been adopted in another country. Domestic remedies have been exhausted in Switzerland, in another country. So that is the first question for those who want to engage in these type of litigations. Who should we sue? Can nationality be a hook, for finding jurisdiction over individuals? So that was one of the complications that also goes to the jurisdictional questions. Basically, nationality is not a requirement for bringing cases in front of the European Court of Human Rights, right? There are exceptions. So the main principle within the jurisprudence of the court is that jurisdiction is territorial. So states only have responsibility with respect to incidents that have happened within their territory. And then they have recognized exceptions to the territorial jurisdiction, which is recognized as extraterritorial jurisdiction. And that's when, for example, a state conducts a military operation within the territory of another state and they have jurisdiction on that area. So whatever happens in that area, that state can be held responsible for that. Or when things are happening on the board of ships or airplanes, which can be considered like the territory of the state, but they are outside its territory actually. So those are the exceptions. Extraterritorial jurisdiction that the court has recognized. What I've argued previously is that sport is another new exception, right? These sport governing bodies, Court of Arbitration for Sport, are bringing individuals all over the world under their effective jurisdiction. They set up regulations, they set up doping, regulations. They can, draw blood from you. They can, take your urine sample, everything. They bring those individuals under their effective jurisdiction. And then how can the European Court of Human Rights deny jurisdiction when those entities within its territory are applying that type of, control over the bodies and even personal choices of individuals around the world, okay? That is something that the judges of the third section, so that was a narrow majority of 4-3 at the third section. That was the thing that those 4 judges recognized and said that, yes, we have extraterritorial jurisdiction here. Switzerland has also, intervened with the right to privacy, the right to non-discrimination, and the right to an effective remedy of this specific athlete here. But 3 of the judges submitted a very strong dissenting opinion in that case, saying that Switzerland had no territorial link with the individual whatsoever, right? None of those competitions have been held in Switzerland. Those regulations were adopted in Monaco. The only thing that links this to us is actually the review that was conducted by the Swiss Federal Court, and that, extremely limits the scope of the case to Article 6 or fair trial rights, not, other issues on the right to privacy, whether DST regulations were proportionate, they were impacting the health of an individual, and that's a totally another aspect of the case. But at the Grand Chamber, that dissenting opinion of the minority at the third section turned to be the majority opinion, where they denied a new exception to territorial jurisdiction. And denied jurisdiction over arguments under Article 8, the right to privacy. So there was no violation of the right to privacy. Not that there was no violation. There was no jurisdiction to deal with that question, to the right to non-discrimination and the right to effective remedies. So the Grand Chamber somehow rolled back the holding of the third section when they engage with those type of arguments, when they deliver the judgment at that level. I have to, clarify here, rolling back those arguments or retreating from that stance was on a procedural consideration. It was not on a substantive ground. So I'm not saying that, or they are not saying that the holding of the third section, when they said that DSC regulations violated the right to privacy or the right to non-discrimination, they were a violation of those rights. They are not saying that. They simply are saying that, well, we don't have jurisdiction to deal with that claim, right? So as things stand right now, they have rolled back that holding of the third section on procedural grounds and denied jurisdiction over those claims. But they rebranded, repacked, and, brought all those arguments to discuss them under Article 6.1, which I think was a very thoughtful approach by the Grand Chamber, where they used the hook of substantive public policy as one of the obligations that the Swiss Federal Supreme Court has in reviewing the CAS awards. So they say that based on substantive public policy issues, the Swiss Federal Court should have subjected the CAS award to a full review of all those claims, whether it's related to human dignity, whether it is related to discrimination, the right to privacy, those type of things. They should have all been addressed by the court, that whether DSC regulations were proportional at all, when it comes to that. So, that is the thing. Nationality is not a requirement to bring a case in front of the court, but there are these jurisdictional complications that, somebody has never lived in that country, had no link to the territory, and still we can find that, state responsible. So that, if you think about it, if the Grand Chamber would have recognized that type of jurisdiction, they basically would have turned the European Court of Human Rights into a global court of human rights, at least within the realm of sports, right? So that was a very, very, very important concern for the Grand Chamber, which we see in like the recent climate change litigation cases as well, where they denied extraterritorial jurisdiction. I see a very big difference here between sports and, climate change disputes, where, for example, in climate change disputes, there are a lot of debates about attribution of responsibility. Who is responsible? How much a state, specific state is responsible? But in sport disputes, we actually have a clear, type of connection with the state by those sporting entities. And also we do have, that type of measurable responsibility, at least when it comes to one single individual in terms of violating their rights. So these are the differences that in terms of jurisdiction you can find in the judgment of the Grand Chamber when compared with the third section of the court. Okay, so the elephant in the room, that was the concept or phrase that my dear colleague Antoine Duval used in his post on this judgment. And he correctly pointed out or highlighted there is an elephant in the room, right? So together with Antoine Duval and Professor Cesare Romano, we intervened as third parties. In this case, raising issues of independence and impartiality of the Court of Arbitration for Sport. This is an interesting intervention because, first, this question was never raised in prior proceedings before the Court of Arbitration for Sport, before the Swiss Federal Tribunal, before the third section of the European Court of Human Rights. We brought and introduced this issue to the court with this third-party intervention saying, hey, there is an issue here that you need to deal with before moving to any other substantive arguments in this case. If CAS is not an independent and impartial tribunal, based on the jurisprudence of the European Court of Human Rights, how can we expect that to uphold the right to privacy, to right to non-discrimination, and those type of things, right? How can we say that the applicant had a fair proceeding in front of the court if we cannot say that this structure is independent and objectively impartial? So we raised this question with our third-party intervention, and interestingly, this became a part of the hearing, the Grand Chamber hearing, in May 2024. The video is available on the European Court of Human Rights website, where the Grand Chamber posed the parties with this question: that do you think athlete had access to an independent and impartial tribunal? So that is a huge development. This was not a question that was raised by the parties, right? Second, this was a question that was considered to be settled, shelved, after the Mutu and Pakistan case, when the third section of the court said that CAS is an independent and impartial tribunal, right? So the Grand Chamber posed the parties with those questions, and they all provided the responses. Switzerland was, had a fierce argument about reopening this question, that this only has came up by a third-party intervention. Why is it now part of a proceeding, and all those type of things, right? And when we go and read the judgment of the Grand Chamber, so first of all, they did not provide a direct answer to this question, right? They started the judgment with excluding this question from the scope of the judgment, saying that this was not a part of the application that was submitted to the court by the applicant. So on a procedural ground, they dropped this argument. But when you go and read the analysis of the court, the majority of the court, you see strong indications, in confirming that there are serious doubts about whether a court of arbitration for sport is actually independent and impartial. I specifically want to refer everyone to paragraphs 200 to 204 of the judgment of the Grand Chamber, where they discuss how this arbitration system is working and how sport governing bodies are imposing a structural control over court of arbitration for sport. By any measure, if you put these findings next to the jurisprudence of the European Court of Human Rights on independence and impartiality of tribunals, you can say that this institution is not structurally independent and objectively impartial. It is different than subjective impartiality. We are not talking about the impartiality of the arbitrators, the individual arbitrators. We are talking about the whole structure, okay? So that is what objectively impartial in the jurisprudence of the European Court means. Furthermore, Judge Shimachkova submits a concurring opinion. It's not a dissenting opinion. It's a concurring opinion saying that I think the majority should have gone even more in finding a violation of Article 6.1 to discuss issues of independence and impartiality, right? She completely uses those same arguments to say that CAS is not an independent and impartial tribunal and not a court that is established by law even, right? So this is a big elephant in the room, if you want to consider it, because it completely undermines the structure of the Court of Arbitration for Sport itself. Thing that has been settled after the Mutu and Pakistan case, and in our opinion, Antoine Dual has also written about this, the question is reopened again. And we believe that should be raised by whoever brings the next case in front of CAS, Swiss Federal Tribunal, or the European Court of Human Rights. That whether this is structured based on the holding of the judgment, and if you want to put it next to the jurisprudence of the court, it is independent and impartial, right? So that is the first big elephant in the room. The second big elephant in the room, which might be somehow challenging for athletes, is the principle of fairness of sporting competitions, right? Let me step back and go back to the award of the Court of Arbitration for Sport. The panel in the Court of Arbitration for Sport said that there is only one thing that we care about, and that is the fairness of sporting competitions. DSC regulations have been adopted, in this regard. So we only need to examine whether they are necessary and following a legitimate aim, and if yes, whether they are reasonable and proportional, right? So they find that they are necessary, they are following a legitimate aim, but on reasonableness and proportionality, the analysis is a bit vague, right? These are the things that I've discussed in that post last year on Opinio Juris. And I want to invite all audience to please, if you can drop it, the link in the chat, please, Valeria. I want to invite everyone to, if you want to have a better picture of this issue, please read that blog post. Fairness of competitions, that's what all Court of Arbitration for Sport cared about. Swiss Federal Court completely upheld the CAS award in that case. Then things came in front of the third section of the European Court of Human Rights. They completely disregarded fairness of sport competition. What is this? Why should we deal with this? This is a novel issue. There is no precedent in the jurisprudence of the court about whether fairness of sport competition can be, an exception to the rights. And fairness of sport competition can show itself in different forms. DSC regulations is one of them. The regulations that are adopted by World Athletics, again, about whether double amputee athletes can run in able-bodied athletes, is another one that they say that those processes are giving them mechanical advantages. That is, again, the argument is we want to keep the integrity and fairness of competition, right? A third section completely disregarded fairness of sport competition, said that this is sex discrimination. We cannot accept that. There are indications in the judgment of the Grand Chamber that might not be the whole story, right? So when we come to the Grand Chamber, we see an evolution of understanding the sport structure. The Grand Chamber touches upon a lot of nuances of the sport structure, sport arbitration, and the complications in these cases. Like, for example, in one of the articles in paragraph 208, they mentioned that the substance of disputes in front of CAS is completely different from other commercial arbitrations, right? So they have a very nuanced understandings, which is a huge step forward when it comes to the Mutu and Pakistan Award and even the third section judgment, right? But the only thing that they criticize CAS for that is the proportionality and reasonableness of the DST regulations, okay? They are not saying a word about necessity of those regulations or whether they are following a legitimate aim, okay? Let me read you a paragraph in the CAS Award, which is quoted in the judgment of the Grand Chamber and also quoted from the judgment of the Swiss Federal Court by the Grand Chamber. So the paragraph in the CAS Award by the Arbitral Tribunal reads that once it is recognized that the reason for organizing competitive athletics into separate male and female categories rests on the need to protect one group of individuals against having to compete against individuals who possess certain inseparable performance advantages derived from biology rather than legal status, it follows that it may be legitimate to regulate the right to participate in the female category by reference to those biological factors rather than legal status alone. Okay? So this is a paragraph from the CAS award that has been quoted in the Grand Chamber judgment, but they never say a word about whether these efforts in ensuring fairness of competitions are not following a legitimate aim or if they are not necessary. Right? They have subjected the CAS award to utmost scrutiny. If you read the judgment, you can see that they completely have understood every single argument in the CAS award. But when it comes to these pillars for finding an exception to a violation of human rights, they don't say a word about the necessity or legitimate aim of these regulations. All they say, they attack it based on proportionality of the rule. They say that because of the health consequences of these regulations on athletes' physical integrity and bodily integrity, these regulations were not proportional to the aim followed. Means that these regulations may follow a legitimate aim, right? But they are not proportional because of their impact on physical health and also the right to privacy of these individuals. Their, the details about their physical characteristics is going to be exposed. People will know that, they have different characteristics, and that is a violation of the right to privacy. That is not proportional and reasonable for the aim that is followed. The first holding that I discussed in that opinion Yuri's blog post as well is that these regulations may follow a legitimate aim and might be necessary, but where they fail is whether they are proportional. That's the exact holding of the Grand Chamber in this case. That is the second elephant in the room, that measures in ensuring fairness of sport competitions might be necessary and follow a legitimate aim. But in this case, they fail on proportionality and reasonableness, but in other instances, they may not. So that is also setting a precedent about whether fairness of sporting competitions is something that can be upheld in the face of human rights arguments or not. I think that's also another important part of the judgment, and thank you for whoever highlighted that they recognize this hierarchy. They said that it's not a horizontal relation, it's actually a vertical relation where sport governing bodies are playing a type of, public foundation role here. So we cannot say that they are completely private. They might be also public. So based on that, they recognize that imbalance of powers between the two. But whether sport governing bodies are going to, comply with that, I'm not sure that is something that they're going to comply, because that whole structure is working based on that type of relation, right? And that is fine. That is not an issue, in my opinion, right? The issue arises when those who are subject to this system are not afforded necessary guarantees with respect to their rights, right? So we may have this, vertical relation, imbalance of power between a sport governing body and an athlete. But the athletes, the individuals who are subjected to this imbalance of powers, should be afforded all the rights that they have under the international human rights treaties, whether global or regional, like the European Convention of Human Rights. That is when this can be a type of balance where we can restrict and subject that power by the sport governing bodies to a type of scrutiny based on the athlete's rights. So in front of CAS and Swiss Federal Court, athlete totally lost all legal arguments. In front of the third section, damning victory for the athlete, right? Violation of Article 8, 13, 14, they even didn't need to go into Article 6, those type of things. So it was a big win for the athlete. But if you want to only, focus on things from the third section to the Grand Chamber, I can also see the victory of Switzerland, because the Grand Chamber ended up denying a new exception to extraterritorial jurisdiction and saying that, Switzerland is not responsible for those type of claims, that it had no territorial link with them. So from, the third section to the Grand Chamber, I also see a partial win for Switzerland, But again, since they upheld the violation of Article 6, this is a big win for the athlete, a huge step forward for other athletes who are subject to the proceedings of CAS.